So how does the fair use doctrine apply to AI training in the US, and how is that different from Europe's text and data mining exception? This is a question we often get, particularly for folks that work in multinational organizations. So in the US, there are over 60 cases and counting against AI developers by rights holders. Most of those cases are for the use of protected content for training purposes by the AI developers. And we're still in the very early days of these court cases. We have only a few decisions we could actually sink our teeth into. And the key takeaway from those that we do have is that all of them take different approaches. And the reason for that is simple. Different facts, different evidence is presented in each of those cases. And the court, case-by-case analysis, based on the evidence before it, makes determinations. And different approaches have been taken in all of these cases. Courts are probing purpose and market harm. Those are two things that they are probing very seriously. They are not granting blanket permission. So we're nowhere close to a green light, red light type of rule. So we expect a very prolonged period of uncertainty. And my personal opinion is that we probably will never get that certainty that businesses need. We are starting to see some settlements, right? Including the largest copyright settlement ever. This is the Bart's versus Anthropic case. It's a settlement for $1.5 billion for using carded works to create a library of content. Largest copyright settlement ever. And we're also seeing other cases settle, particularly in the music space. Now in the EU, it's a different approach. There is no fair use in the EU. There is a text and data mining exception. And there are two different exceptions that we're dealing with here. If you're doing TDM, text and data mining, for research purposes, and you are a qualifying institution, and you have lawful access to those works, then the exception allows you to do TDM without needing to get additional authorizations. If your TDM is for commercial purposes, you have to first check whether the rights holder have reserved their rights, or opted out is how sometimes people refer to it. If the rights holders have reserved their rights, you cannot use those works for TDM purposes in a commercial setting. And so between the uncertainty of the US fair use and the different approach in the EU, as well as all the reservations of rights, what we're seeing is a move towards licensing uses of works for training and other uses in AI systems.